Thank you very much indeed, and good afternoon, everyone. I was proposing to talk for 5 or 10 minutes and then see if we had questions, and if we weren't overwhelmed with questions, I can always keep going and until you're absolutely terrified witless by my observations, or so outraged with what I'm saying that you feel you need to respond. My name is indeed Michael Bowsher. I'm a barrister, and I specialise largely in public procurement, and therefore, and we've been dealing with health sector procurement for 20-odd years in my chambers. I think probably we do have the largest group of lawyers in the country specialising in public procurement law. That's probably quite a big boast at the moment because a lot of people are getting more involved in it, but we've been involved in it for at least 20 years, and we've been involved in health sector issues. And so I think a lot of my colleagues are very well placed to comment on the issues that arise from the interaction between the health sector regulations and the old public sector regulations. And there's a little brochure out there which we've prepared, or my colleagues have prepared for you, which summarises some of the key issues in the area. Why is this a big problem? A lot of people, of course, are coming to NHS procurement. It's been a sort of hot topic as the recent legislation went through Parliament, and with the problems with the regulations. Why has this become a huge problem? Because procurement law has not sprung from the ground in the last 6 months, and a lot of the particular comment from government, rather talks as if you can draft regulations without any history or baggage. Procurement law has been out there in this country since at least 1991, and a lot of what we see in the NHS regulations is frankly vague and unhelpful, at least partly vague and unhelpful, because the words have their own historic meaning, and one of the difficulties we're going to have, I think, is in the health sector, is integrating what the government wants us to treat as a sort of a new subject back into that old case law. So, what I was going to do is try and summarise, in a very general way, summarise the core ideas or the core areas of procurement and focus on in due course as to what the problems are in the health sector. There has been public procurement regulation in this country, as I say, for 20 years. That's the standard process. It's applied to lots and lots of health contracts. Many of the people out here today have been litigating with NHS bodies for years for contracts for construction, for the provision of kit, for the provision of services, for the provision of IT services, and even for the provision of healthcare services. Those regulations have been in place, and that framework has been in place for a long time. What is different is that healthcare services were always in a slightly different category, so that the standard regime provides a series of complex requirements about what procedures you follow and so on and so forth. That's never applied to healthcare as such, so the provision of actually the service of the medical service provided by a doctor or a medical professional, or the specific service provided by a diagnostic laboratory, for example. What the government has tried to do, without appearing to make any difference, as it were, to try to fudge the situation in a way, is put in place some regulations which occupy the space which they have created by the restructuring of the NHS. Because by creating contracts, they've created thousands of contracts which are now, in principle, subject to the old EU regime and all the old EU case law. Why is that a problem? Because the old EU case law says that any contract with a cross-border interest for services, even if it's in the healthcare field, must be advertised so as to open it up to competition. That's what the word transparency means in the regulations. Now, a lot of what Monitor and the government have talked about suggests that that advertising and so forth is optional. It's only optional if the judges and Monitor are going to read the word transparency as meaning something different in these regulations from what they've meant for the last 20-odd years in all the other procurement regulations. And I think we can say with a reasonable amount of certainty that they're not going to do that. Courts don't say, well, words mean one thing here and something else somewhere else. They're going to treat them as meaning the same thing. And so when the regulations say that you must comply with transparency, equal treatment, non-discrimination and so forth, they are bound to follow the existing case law, which goes back 20 years or so. What will that mean? That means that there will always be that obligation to start a tender process whenever you have a new contract, as long as the contract is above the relevant threshold, as I say, the cross-border threshold. And this is, of course, another area where the regulations are splendidly unhelpful, because you have the area of what I've called standard procurement, the stuff that's been around for 20 years. You've got this new area which is provided for by the regulations, healthcare, which these healthcare regulations provide for, health procurement regulations. And then you've got very small contracts, so small that they fall below the threshold of interstate trade there's no cross-border interest. Now, you might think, well, most of the contracts I deal with aren't actually of any cross-border interest. The last time a German applied for any of my contracts was whenever. Unfortunately, the Commission and the case law has always defined that threshold very, very low. There was a case about kitchen equipment in Finland that said that although there's actually a fixed financial threshold of about 100,000 euros in the legislation, because that particular contract might have been provided by a Swede, then there's cross-border interest, and so all of this baggage about transparency and advertising comes in. So what I suspect it puts an important burden on commissioners and those responsible for commissioning to think about, is this contract actually of cross-border interest, unfortunately? Because one of the routes out of this is to say, well, this is a very small contract, I don't need to worry about EU law at all. And we'll come on to an example as to why that might matter. In most situations, what these NHS procurement regulations are intended to do are basically say, well, these are the rules you have to apply anyway. You don't need to worry too much about whether you're covered or not, because what the government has in fact done is extended the scope of procurement law further than it had to. And they've been unhelpful to the health sector probably in two ways. They've first taken health procurement legislation further than the EU law actually required. And they've then, rather oddly, not taken the opportunity which they had in the current reforms of procurement law going on in Brussels to take healthcare out of procurement law. What has happened, and blowing my own trumpet in another capacity, I'm a legal trade unionist, as it were, and we've negotiated an exclusion from procurement law for certain legal services. Now, the government, if they'd wanted to, could have tried to get some healthcare into that same bracket. They didn't try, presumably because that's not what they intended to do. So when we get in a couple of years' time, when we get the reformed EU package, if anything, the law will be even worse or more onerous. What you have then is a system of regulation which, as you will know, imposes a number of specific obligations on you to advertise, to compete. If you're going to advertise, you're going to have to respect equal treatment. It's difficult to see how you can avoid having a competition, because if you've advertised and people respond to your advertisement, if you're going to treat them equally, you're going to have to find some way of dealing with the competition. Yet at the same time, you have to respect all of the other statutory obligations to consider how the integration of services and the interests of patients are reconciled. It's not entirely obvious how that's going to work together. And again, in a moment, I might touch on some of the obvious problems which that raises. Monitors produce quite a lot of material and case histories and so forth, which they think are interesting. It seems to me that throws up two or three obvious problem areas which are going to come up fairly quickly, I would have thought. The first is likely to be in the area of incumbents. What do you do when you have an incumbent provider who you're rather happy with and you don't necessarily want to switch? if you are subject to transparency and equal treatment, as you must, and you are dealing with a healthcare contract, so you must necessarily have to comply with those obligations, you have a real problem, because those words do in fact bring with you an obligation not to prefer an incumbent. You need to ensure that incumbents do not have an unfair advantage. So, although you might say, I'm going to look at the statutory requirements of the goals of integrating the services and so forth and say, well, the incumbent does that rather well, I'm going to treat that as it were as the trump card. It seems to me that in due course there will be a decision of either Monitor or the courts which says that must be wrong, because you cannot discriminate in favour of incumbents. You have to find some way of balancing up the playing field to allow new entrants to come in, because otherwise you wouldn't be paying respect to those obligations. The topic which of course has created a lot of excitement is the whole question of one capable provider. When can you decide there's only one capable provider? Again, this is why it's important to see the context of this law, that it comes from EU law and that you're probably subject to EU law in any event, at least for the larger contracts, because the exception that says you don't have to go out to tender if there's only one capable provider will be just that, an exception. And the case law has always said exceptions are interpreted narrowly. Whatever the government may want to say or want to imply, they're always interpreted narrowly by the courts, and that will mean that the default position must always be advertisement, and you must genuinely prove that there is only one other capable provider. Now, the real problem is going to come, I think, when you start having people repackaging their services in a particular way. They will say, so as to comply with the statutory requirements of service integration or whatever, and then say, well, there's only one person capable of meeting that particular assembly of demand, of supply of service, and therefore there is only one capable provider. And I'm not sure, my colleagues may have a different view on this, I'm not sure the regulations have really dealt with that, but it seems to me that certainly in the courts, if it were to come up there, the likely answer is to be, no, you can't do that. You can't just repackage service so as to eliminate competition. Certainly from an EU law perspective, you will then have repackaged the service so as to avoid competition, and that you are not permitted to do. And EU law in this regard must come above a mere UK statutory instrument. There is then a whole area of problem to do with the overlap between the public regulations and the NHS regulations. Now, a very large amount of the work we do at Monckton Chambers is not to do with the litigation. We do that as well, but a lot of it is to do with advising on designing procurements, how to run procurements, how to come up with criteria and so forth. One of the practical problems we're going to have is how to match up two different sets of requirements as to what the criteria for selection are going to be. Transparency requires that you effectively say what you want and then review the tenders by reference to precisely the criteria that you have identified. Those criteria must be defined in such a way that they are tolerably clear to anyone bidding, any experienced bidder in that sector. Now, that raises a number of difficulties, in particular where the criteria may start to become unclear, particularly where trying to reconcile some of the different requirements. If you're dealing with a mixed procurement, let us say a procurement that it may involve some healthcare services but also some IT services, and you're not sure which regime you're in, what you're going to end up doing is having to match the two systems together and probably try and take some of the criteria from the NHS procurement and run them as part of the public procurement service, requirements. That's a particular problem because capability is a statutory requirement in the NHS regulations, and under EU law you're not entitled to use capability as a requirement when you're evaluating bids. the capability of providing is something you should have assessed before you looked at the bids themselves. You decide first whether someone's capable, and only once you've done that do you then actually look at the bid. So there is in fact a conflict inherent within this way of trying to put the two bits of legislation together. I was going in the last sort of 5 minutes just to go on to deal with issues about remedies and challenges and how that might be raised. I don't think to stopping there if there are any questions on the design of procurements, criteria, and what is or isn't permitted. If not, I'll just move swiftly on to remedies. The next area, The next area of difficulty is the fact that we have created a lawyer's paradise, but paradise for no one other than lawyers, of a system of dual remedies where you can go to court or to monitor. Of course, monitor itself will be subject to court review, so either way you're going to have multiple opportunities to end up in court as either a challenger or a commissioner. This regime, again, has its own history. If one is in the public contracts regulations, the real disaster for the commissioning group is that we have a special procedure that if you're covered by the public contracts regulations, the very fact that a claim has been started actually stops you from signing the contract. And you can't get to sign the contract without going to court. It has to be court, not monitor, and get the court to actually give you permission to sign the contract. So I can see that certainly for larger contracts, for people, and I've seen this already with some larger contracts with commissioning groups, what the larger suppliers will want to do is go off and stop the contract being signed simply by paying about £1,600 at court, get the claim form issued and served on the group, and then all the burden and cost of getting the contract unstuck lies with the commissioning group itself. Of course, one way out of that will be to say, well, I'm not covered by the public contracts regulations, but the only way of doing that will be to say, well, my contract is so small that there's no cross-border interest. This is hence why I mentioned the point earlier on. It's so small, there's no cross-border interest. This is only a very local interest, and therefore only the health procurement regulations apply. The logical difficulty with that that may work to start with, I think, but the reality is that the NHS as a whole is going to be a very desirable market for providers elsewhere in the EU. And it may very well be that your particular contract in a particular area is not in itself, on its own, of great interest to a Belgian or a Swedish provider. But if it is one of a group of demand, which as an aggregated demand, or not aggregated as a group, is of interest, and so that the Belgian provider is interested in coming into the UK or whatever, then it seems to me that is enough to trigger the EU element, and enough to trigger, therefore, this real problem that contracting is going to be held up all the time by simply the issue and service of a claim form. If you've gone into court, you can't go to monitor. But if the challenger hasn't gone to court, it can also run its challenge with monitor. Monitor has rather interestingly been given the power to declare a contract ineffective, which is remarkable because this was only a concept only introduced into English law 3 or 4 years ago in the last round of procurement law reform driven by Brussels. At the time that it came in, it was treated and regarded by government here as the most appalling interference with English law, and the most greatest outrage. How could these mere foreigners be allowed to tamper with our contracts? Yet it has only taken them, I think, 3 or 4 years to see this as an absolutely great little wheeze to terrify NHS purchasers with, and so they've put it into the NHS procurement regulations, but actually they've beefed it up. In some respects, they've made it even worse in this new version. Or at least made it easier, more readily applicable. And so this does raise the stakes, I would suggest, for commissioning groups if they don't go out to competition, if they make errors of judgment in deciding, for example, whether or not they can avoid tendering by saying there's only one capable provider and so forth, because they risk Monitor simply having the contract torn up and put to one side. Finally, the ghastly risk, even if you get your contract, is certainly if you're in court, there's always the risk that the commissioning group will find itself being sued for damages by the unsuccessful bidder. So you may find yourself with a lovely contract, but still a huge liability for someone who would have liked the contract. They haven't stopped you from signing it, but they're earning, for every pound you pay to the contractor, you have to put in the bank 5p of profit damages that you might have to pay to someone else in the future. In short, this is not the way, I think, that one might have designed procurement law if you'd had a blank sheet of paper for the NHS, but hey, is that really a surprise? I have a couple of little teasers, as it were, to take on, but if there are questions, maybe that's...
Should we take some questions? Can you get round it by having an internal market in which none of this applies, and then you decide what's tested externally?
For testing, well, that's the problem. If you're going to have a contract, and you have to have a contract, if that's the route you're having to go, then you have to advertise. It seems to me that's the necessary consequence of the EU law history. The prior question, which I think you may be referring to, is whether
can you play shops without going to Europe?
Could you go to what you might be able to do? And I think this only works once at the early stage. Is to say, let's run a pilot scheme. It probably can't be a healthcare pilot scheme. What you do is you call it a management consultancy pilot scheme, or some scheme. You'll have to. There's a big book of services. It's about that big. It's really, really boring, but it's got a little number against every kind of service, and it tells you there's a different number for building a castle and one for building a palace and things like that. And you want to find a code for your pilot scheme, which is non-standard, so it's not construction, and is not healthcare. And then you'll run your pilot scheme with some healthcare on the back, and you'll say that run this as it were as a sort of a dummy, and that will then test the market as a way of finding out whether or not that's actually what you want to do or not. Now, what I've not been able to do is work out whether you can actually make the classification work. Rebecca Haynes, one of my colleagues in the audience, has come up with and I has thought about this further. I don't know whether she's found a cunning code to rely upon, but that I think is what you have to do. But it's only going to work once, because once you then have decided, yes, this is something I really want to do, you're then necessarily going to be either buying healthcare or healthcare with some IT. So you're either going to be in the healthcare or in the souped-up standard regime.
Okay. Any questions arising from this? Apart from, would you start from here if you could design it from scratch?
Yes.
We've got a microphone. If you could say who you are.
I'm Carol Eastwell. I'm commissioning manager. In between jobs at the moment, going to a new commissioning area in Kent. I just wondered how all this fits in with supporting where we need to support our main providers, so like our acute providers. With the new Health and Social Care Bill, there is a need for us within commissioning to support our acute providers, and that's in a lot of our actual plans for the future.
Sorry, you need to be near the speaker to hear you. Well, in short, it's one of the many. I mean, all of that stuff at the beginning of the procurement regulations that you're supposed to have regard to is rather hard to reconcile with the history of procurement law, and I think that someone is going to come unstuck. It will turn around how you design your criteria, I think. If you can say, well, what we need is from a bid is to be competitive, and it meets the existing demand, and it respect various other local requirements, you may be able to get away with that. But what is absolutely clear is you cannot say that you cannot create something which discriminates in favour of an existing provider. That is exactly what EU law says you can't do. And that is one of the sort of the dark, unspoken tensions in this legislation, which simply has not been grappled with. Indeed, EU law goes further than that. To give one medical example, there was a case a few years ago in Spain about the provision of domiciliary oxygen. And the Spanish medical service required that the bidder have an existing set of depots for their oxygen services in Spain. And that was, in a way, it sort of was sensible, but obviously discriminatory, because obviously there was only one person in the world who had a network of domiciliary oxygen provision in Spain, namely the person who had the existing contract in Spain. Why would anyone else have that network? So the requirement itself was a sort of circular discrimination. What the Court of Justice, this went all the way to the European Court of Justice in Luxembourg, and they said, no, you cannot do that. What you can do is require people to put in place that network if they win the contract, but you can't say we're going to give preference to people who already meet this demand, already have this local provision. That will fall foul of EU law. I've no doubt about it.
More questions? At the heart of this, I think, is the issue of, and I say this as an observer from social care looking at health, is the NHS operating as if it was another country outside of the EU?
Yes. Well, I think there's a lot in that, and sort of ignoring the fact that there is this lengthy history. And, of course, social care has had to grapple with this for a long time and has had to deal with all of these problems. And we've had exactly that sort of these problems in social care, where you've had existing networks that have been in place for a very long time losing out because the larger names are better placed to come. Well, they may not be better, but they are able to put forward a more attractive bid.
Were you looking to come in? You I think I sort of cut across you. But
No, it was just picking up on the last point, in that you can't discriminate, but you can. I'm right thinking you can ask how bidders would, as you say, build those networks into other stakeholders. So I'm thinking, there are services that we've transferred from the PCT into the council, in Doncaster Council, where we work. Obviously, the incumbent is either the acute or the current, foundation trust. And we understand the procurement rules we're under very, very well. And we've got a one-year contract, with those incumbents for stability, and that's been waived by our senior managers. But we're obliged to tender these services. But some of these services do necessitate some links into existing health contracts. It's how you deal with the procurement rules plus keep those links. That's the challenge, isn't it? I guess.
Yes. And of course, sometimes it will be obvious to any sensible bidder that the only way to provide this locally is to acquire in some way. Often by two people. There's no sort of abstract way. Quite often you'll find that the new person comes in and two-piece across an existing business as part of some acquisition, because that's the only sensible way of doing it. But what you can't do is say you can't say you must take over that existing business. That's going to be the real problem, because the hypothetical Cypriot bidder, there may not be many of those around, but the hypothetical German bidder is certainly entitled to come in and say, no, there's a greenfield site out there, and for one reason or other I'm going to build the UK National Centre for whatever it is that you're talking about. I've got planning permission to build it there, and that's where I'm going to do it from scratch, and everyone else can just go hang.
Any more questions? We're almost up against time. If not, can I just mention, for those who haven't picked on it, if you want to hear